Good day everyone, this is Regine Peñalosa and I'm going to tackle about the articles 1267 and 1269 under the law of obligations and contracts. So before we proceed with the contents of these articles, let us discuss first our objectives. The first one is to define the respective contents of Article 1267 and Article 1269. The second one is to set an example situations of each article, and the last one is to understand the learning content. The Article 1267 refers to the difficulty of service or performance manifestly beyond the intention of the parties. In Article 1267, it states that when the service has become so difficult as to be manifestly beyond the contemplation of the parties, the obligor may also be released therefrom, in whole or in part. To understand this clearly, we have the Filipino definition for the Article 1267. It means that kung ang serbisyo ay napakahirap at higit pa sa makakayanan ng lahat ng partido, sila ay maaaring maging libre na sa obligasyon na gawin ang serbisyo na ito sa kabuuan o sa parte man. In simple terms, the Article 1267 only means that if the obligor was done doing his or her part and the creditor's satisfaction was not completely fulfilled, then the obligor is not liable in any means. To understand this clearly, let us set an example situation for this. So to illustrate, if A contracted B to construct deep well at the price of 50,000 pesos, but for some reasons, A was not satisfied with the water source of the deep well. However, B explained that he cannot extract deeper than 100 feet anymore since the contracted price was only 50,000 pesos. It was not enough to cover all expenses for reconstruction. B is released from the obligation. In this case, B owes nothing to A since B already complied the obligation. It means that B do not have any liability even when A was not fully satisfied, since B's level of obligation is only based on the negotiated price or contract. Question: when can we use the Article 1267? The Article 1267 can be applied if the following conditions concurred. So the first one is the event or change in circumstances could not have been foreseen at the time of the execution of the contract. The second one is when it makes the performance of the contract extremely difficult but not impossible. The second one is it must not be due to the act of any of the parties and when the contract is for a future frustration. So let us proceed with the Article 1269. In Article 1269, it states that the obligation having been extinguished by the loss of the thing, the creditor shall have all the rights of action which the debtor may have against the third persons by reason of the loss. In Filipino definition, it means that kapag ang obligasyon ay nawala sa pamamagitan ng pagkawala ng bagay, ang pinagkakautangan ay magkakaroon ng lahat ng karapatan ng pagkilos na kung saan ang may utang ay maaaring magkaroon laban sa taong may dahilan ng pagkawala ng bagay. Although the obligation is extinguished by loss of a thing without the debtor's fault, whatever action the debtor may have against the third person by reason of the loss is transferred to the creditor in order to safeguard the interests of the latter. The right of action includes the insurance indemnity that may have been received from the third person. In simple words, among the three parties, the one who has the right to file or take any legal action towards the reason of the loss of thing is the creditor instead of the debtor. To understand, Let us set an example for this one. Eminem obliged himself to deliver to Cadbury a specific Carabao. Without the permission of Eminem, his neighbor Ferrero took the Carabao and used the same for blowing. Later, the Carabao was lost through Ferrero's fault. Eminem's obligation was extinguished, but Cadbury acquired the right to file an action against Ferrero to recover the damages for the lost Carabao. In this scenario, Eminem is the debtor and Cadbury was the creditor. However, Ferrero was the third person, which is the reason of the loss of thing. Since Ferrero was the reason of the loss of thing, Cadbury, the creditor, has the right to file any legal action to Ferrero in order to recover the damages for the lost Carabao. Thus, Eminem's obligation is extinguished. So that will be all. I hope you learned something in this video. Thank you for listening.